Right, good afternoon, everyone. My name is Jessi Thaller-Moran. I'm an attorney with Brooks Pierce, and I'm here with my colleague Natalie Sanders to present on returning employees to work in a COVID-19 world. I know this is a hot topic on everyone's minds right now. I know everyone's anxious to get back to normal and see what that looks like, but we're going to walk through some legal considerations for employers as we enter this new phase. And I do want to provide a brief disclaimer here in the beginning that the content of this webinar is provided for general information purposes only. It should not be considered legal advice or used as a substitute for consulting an attorney for legal advice regarding your own matters. So as I mentioned, my name is Jessi Thaller-Moran. I'm an attorney in the Raleigh office for Brooks Pierce here in North Carolina, and my colleague Natalie Sanders will also be presenting today. She is based out of our Greensboro office. And you will see our smiling faces and our contact information again at the end of the presentation, but we did want to make sure you knew who was presenting for you today. So what we've done in an attempt to kind of catalog the vast amounts of information that are available online, and I'm sure many folks on this presentation have felt a little bit overwhelmed by the information swirling around, we've tried to categorize it into kind of three main groups. So we'll walk through preparing workplace policies and facilities for returning your workforce, practical matters associated with returning those employees. So that will include logistical hurdles and paperwork to be thinking about. And then a final section on complying with new laws that have been enacted this spring that will intersect with a lot of the issues we talk about today. And with that, I'm going to turn things over to Natalie.
Hi, it's great to be here with everyone today and talk about this hot topic. I get to talk to you first about preparing the workplace policies and facilities. And we're definitely doing this from the employer-employee standpoint. And because of that, we are emphasizing the Occupational Safety and Health Administration as the starting point. We're doing that even though you see a lot pointing you to the CDC and other resources. OSHA is the enforcement agency when an employee is going to raise a concern about workplace safety. Because CDC is not going to take a workplace complaint from your employee, nor is the North Carolina Department of Health and Human Services, it's going to be OSHA. We are encouraging all employers to look there as their starting point. And so when you do that, OSHA has some great resources. First off, they have a worker exposure risk assessment that you can do. And then from that, use their guidance for preparing your workplace for employees returning. And then they have a great PDF that's just very concise, about 10 steps that all workplaces can take to reduce the risk of exposure to COVID-19. So those are your first starting point resources. Then, depending on what your industry is, you would go to other specific OSHA resources, and they have them for each of the specific industries identified here. And after you go to OSHA then, the first step is assess your worker exposure risks. Then you would develop your plan, your preparedness and response plan, based on that risk exposure assessment, and then plan for any contingencies beyond what you have in your plan. So let's start with that risk assessment. How likely is it that your workers are going to be exposed to COVID-19? The first two high-risk areas, very high risk and high risk, you're probably going to be in some sort of healthcare or mortuary setting or something connected with those. So those are going to be your high risk areas. If you're in those, you've got a lot of other guidance. You've already got a lot of OSHA standards in play. You've got CDC recommendations. You've got very specific regulations going on. the little bit lower risk areas, you have the medium risk, and then you have the lower risk. And as we go through and we talk today, we're really going to be focusing on these two areas, because looking at those of you who've signed up for our webinar today, it looks like most of you are going to fall into those categories. So you've got medium risk. When you go through this process, if you look and you say, do any of the jobs require a frequent close contact with someone who could be infected? Probably not someone who is known to be a patient. You're outside of that healthcare setting. But more likely, this is contact with the general public, right? So this is going to be retail settings. This is going to be where you're interacting with people as part of your job. Then the low exposure risk. You're not required to interact with people who are known to be or suspected of being infected. You have minimal contact with the public, and you're not working right next to your coworkers. So those are the two main areas of risk that we're going to really be focusing on as we talk. If you're in the higher risk areas, you're going to have another level to be examining. But the process is very much the same. And so what is that process? You have this risk assessment, and you figure out what it is we need to have for our workplace and our facilities. And it may be different even within your company, because you may have office positions that have a very low risk, and then you may have some sort of production, or you may have some sort of retail or some interaction with the public, which would put people into more of a medium risk. So even within your company, you may have different areas that have different risk levels, and you would need to differentiate those. When you do that and you're differentiating what is needed in our workplace, just make sure you're making those differentiations based on the job and not any factors that might be discriminatory. And what do we mean by that? We mean don't, even if it's well-intended, think to yourself, well, I have a lot of older workers in this area, so I'm going to have a different standard for them because they're generally higher risk. Focus on what the job involves, and we'll talk a little bit about high-risk employees later. So it's not that we're ignoring them, but we're just reminding you that those discrimination laws are still out there and applicable. And so as you start imposing and changing things in your workplace, you want to be sensitive that you're doing it for the right reasons. All right, so step 2, develop this plan. Is it required by law that you have a COVID-19 preparedness and response plan? Does OSHA require that of you? The answer is no, it's not required by law. But like we said, employees who have concerns about their workplace, they don't think it's safe, they think something is wrong, the place they're going to go and complain is OSHA. And according to OSHA's guidance, employers should have these plans. And it's not required. It's a recommendation only. It's a guidance. It's not binding. So if you don't have one, you're not violating the law. But if an employee does go and complain, what's the first thing OSHA is likely to say? Provide us a copy of your preparedness and response plan, right? So we're recommending that everybody have one if they can. Plus, if you're one of those businesses that has been closed and now we're in phase 1, we're reopening, or maybe you're going to open in phase 2, you're getting ready. If you go through this process of getting ready and developing this plan, you're going to be creating a situation where your employees are safe and they want to come back to work in a safe environment. Because as we'll talk about later in the practical aspects of returning employees, one of the things we're finding is there are a lot of employees that don't want to return. They don't feel safe. They're feeling insecure. So developing this plan is a great way to alleviate those concerns and make employees more likely to want to come back to work. So what do? we go through and we analyze what basic infection prevention measures do we need, what policies and procedures do we have in place to identify people who may be ill and get them isolated away from the other workers or our customers. Communication about what we're doing in the workplace. Where do we have flexibilities? What protections are we providing? Then what about administrative controls? This primarily focuses on educating and training about the other measures, like basic infection prevention measures and things. And then planning for any personal protective equipment or engineering controls that may be appropriate for your work environment. So we'll quickly talk about each of these areas, what things you would be considering as you go through this, and then we've identified a lot of resources for you. So preparing to implement basic infection prevention measures. That's going to be one of the highlights. And you're probably inundated with information about this. Again, what we want you to remember is make it specific to your industry and make it specific to the risk level your employees are experiencing. But this is going to involve things like, what are the hygiene measures? And making sure there's education and posting about those. Encouraging sick employees to stay home, developing those kinds of screening measures. And what about educating on respiratory etiquette, hand sanitizer, social distancing, telecommuting. You want to discourage shared use of equipment like phones, set up your routine cleaning and disinfecting. These are the basics, the things you've been hearing about and seeing about. So putting this into the right framework, we have OSHA telling you, make a plan that includes these things. But OSHA isn't setting out the details. So if we go to the next slide, you'll see we're telling you where to go get the specific things that would go into this. So the CDC is prime resource because they have guidance for the workplaces, they have implementation strategies, they have guidance for reopening and cleaning. They have a lot of details. So if you just go to their website, you go to the resources for business. If you're a specific industry, they give you specific guidance. You'll use that. If it's generalized, use the generalized. But this is where you're going to find all the posters you need, all the things about how do you sneeze and cough and what kind of hygiene measures should we have. So that's where the specifics are located. And the next slide gives you, if you're in North Carolina, you'll want to go take a look at the North Carolina Department of Health and Human Services website. They have specific resources for North Carolina employers specifically designed for phase 1. So you're going to find there an actual employee checklist that you can use to screen your employees. You don't have to make it up. They've done that for you. You'll also find there a checklist for how do I decide if an employee should be allowed to return to work. What's the standard for that? Again, you don't have to make it up. They've done it for you. They have a little checklist that tells you if an employee's been sick and it might be COVID-19, here's what it takes for them to be allowed to return to your workplace. So great resources there. They also have posters, and then they tell you specific information about our phase 1. If you have facilities, employees in a different state, I highly recommend that you go and look for those state-specific resources, because while ours is pretty general, I've seen in other states where it's very, very specific, and in fact, in some states, this preparedness and response plan that we're talking about is required, that employers must actually set one up. So you want to watch for that. Also take a look at what county and city you're in. They're allowed to have more restrictions in place than what the state has put in. So to the extent that you're in a locality that has its own orders still in place, I'm located in Guilford County, and we're currently following the state guidelines, so we wouldn't have to go that route here. But many counties and cities do have other standards that you need to check out. And then, of course, anything industry specific. And I say that with respect to the CDC and the Department of Health, but also take the time to look at any industry-specific things from your associations, your trade associations. They're going to have great resources. A lot of times they're going to be national, so you also have to make sure you're doing your own diligence looking at your state things, but they're going to have some good resources for you there as well. All right, so once you've gone over and thought about all of those basic prevention things, one of the very important elements that you have is isolation of sick people. The idea is that we're going to try to keep them from coming in. You're going to have postings and you're going to have screening. But what if you have someone who's in the workplace, in your facility, who is exhibiting symptoms? So you need to think through, what can you realistically do? A lot of the recommendations are to isolate that person, get them away from others. Our recommendation would be, if you have a workplace where someone who starts exhibiting symptoms can immediately leave without coming into closer than 6 feet of other people, they should do so. And then let the supervisor, let HR, the right person you designate, know by calling in and saying, hey, I started coughing, I'm concerned, I've left the facility. And then you go from there. If that's not possible, you need to make sure employees know they should be 6 feet away from people. They should let someone know, preferably a supervisor, but at least get the attention of another employee and say, hey, I'm not feeling right. I'm staying here in the restroom. Let somebody know. And then make sure there's a plan in place so that people who may have to interact with that person can put on a mask, that there's maybe a mask to provide to that person so as they exit the facility, they're not exposing others any more than necessary. Make sure you have things in place for cleaning. And then doing that interview process of who has this person worked closely to, who have they been closer to 6 feet, and make sure that you're taking measures to have those employees specifically watch for symptoms and perhaps wear masks in your workplace as well. What kinds of resources do you need for figuring this out? They're very similar. OSHA's guidance on setting up this plan goes into a fair bit of detail here. CDC has guidance as well. And again, you can go and look at the Department of Health and Human Services. Resources each time as we go through here are going to be pretty similar. All right, our next phase in looking up and setting up this plan is going to be communication about your workplace flexibility and your protections. Make sure the employees know what you're doing. And then this also has in it the element of examining what your current policies and practices are. Take a look through your handbook. Is there anything that's going to be inconsistent with our current COVID-19 workplace? And so some of the examples that get thrown out here would be like, maybe you have a policy that requires a doctor's note for employees who've been out sick for a certain length of time. Well, in our current environment, and as things sort of change, it may not be possible for an employee to get that kind of return to work note, because oftentimes someone who has COVID-19 symptoms and they're not severe is going to end up doing sort of a video call with a doctor. Doctor's going to say, you might have it, you need to stay home, you need to isolate, and check in with me later. But they're never really going to have that diagnosis. They're never really going to see the doctor. And so you may not be able to get that doctor's note. So you have to be thinking as you go through, what are your normal policies, procedures, and practices, and where might we have to have some flexibility? And then communicating, I think it's very important to communicate your overall plan. On these specific things, you might communicate that if you're having trouble with one of these things, like getting a doctor's note, let us know. Kind of engaging employees to let them know that there's going to be some flexibility there. Again, resources for this, you're looking in the same places. All right. The next area is administrative controls. And this has to do with the things that require action by you or your employees. And this is going to be covered by a lot of the other things we already talked about. It's going to include the things like a lot of the preventative measures, because preventative measures may include social distancing, right? That's something we all have to do to carry out. This element has a lot to do with the training and the educating on it. So if you're going to have employees in the workplace and you've decided we're going to wear face coverings, well, do they know how to use them properly? What about extra cleanings that might be taking place? Are there cleaning supplies that employees don't normally work with, but you're providing them? You would need to provide the resources and the training for those employees on how to do that. So this has a lot to do with educating about the things that employees are required to do to help you carry out. And again, we're going to be having very similar resources for these. And they do have good resources, and I think they've gotten them fairly well organized. They might not have been at the start of all of this, but I think you're going to be able to find things like OSHA, their general recommendations for training people on using normal cleaning supplies. All of that should be available to you. All right, the last thing that I really want to focus on here has to do with protective equipment and engineering controls. So your PPE, your personal protective equipment, that's things like your gloves, your goggles, face shields, masks, respiratory protection. Do you need that in your work environment? And again, that's very specific based on what the risks are. You can go and look at a lot of the guidance that's out there, especially if you're in the phase 1 and you're looking at North Carolina's Department of Health and Human Services. They're going to tell you what's required versus what might be recommended. And generally, they recommend that you allow your employees to use a face covering. It's not required if it's a very low-risk environment, but they are recommending that it's allowed. So look at those subtleties and make the right choices about personal protective equipment. And then make sure any personal protective equipment that's normally required in your employee's job is provided, that it's checked, that they're using it properly, especially if it's respiratory to protect the employees. You want to make sure that there's good fit, that all of that is in place. Then your engineering controls. These are things like the physical changes to your facility. It might be the plastic sneeze guards being installed near cash registers, increasing ventilation. If you look at the North Carolina Department of Health and Human Services for employers that have been closed, you've actually been closed and not functioning, and now you're reopening, they tell you to do a check of all of your basic things in the workplace, like your water. Think about that. Water hasn't been flowing through those pipes in a good while because no one's been there to use it. What might be taking place there? So they're recommending a check of all of those types of things, a check of your air conditioning. Just make sure that while everything's been closed down, as you start things up, there aren't risks there. But they're not necessarily saying you have to change anything, but they do recommend going through that check. All right. So resources for this, same ones. And after you have your plan in place, what additional considerations do you need to be thinking of? We're telling everyone plan for contingencies. So it's great. You set up this plan. Make sure the plan includes a designation of someone who's going to monitor for the what ifs. What if the government orders change? So we move from phase 1 to phase 2, and the North Carolina Department of Health and Human Services issues different guidelines, different posters. OSHA and CDC, all of you are on this webinar, so I know you've been looking at information, and you know these things have been changing regularly. So designate someone who's going to be responsible for watching for these changes. Also be thinking about contingency plans for what if we have increased worker absences? You know, as we start reopening and workers get back out there, it's not all going to be perfect immediately. We're going to have pockets of outbreaks. We're going to have issues come up where maybe there are some cases in a school in the fall and the school closes and you've got a group of workers out again. So start planning for those contingencies. Plan now for increased worker absences as well. It's hard getting employees to come back. There's a lot of fear and concern. And you may have people who are high risk situations as well. All right. Those are the things associated with getting back and looking at your facilities, looking at your policies and doing all of that advanced planning. Now, what about the practical matters? You've done all of that. They're coming back. I'm going to let Jessi talk about that.
All right, so I forecast this a little bit in the beginning of this presentation, but a lot of this is going to be thinking through the logistical hurdles of bringing back your workforce. And I know we're all tired of hearing, oh, this is unprecedented, oh, this is a unique time, but that's truly, truly the case in the employment space. And so there are a lot of moving parts and it's a learning curve for all of us, but the goal for me coming out of this section will be for you all to understand where you need to have plans and policies in place and where you need to train management to respond on kind of a fact-specific basis, because it's going to be walking a little bit of a tightrope between those two approaches. So if you have worked with us at all during this reopening phase, you know that the first question we're going to tell you to ask was whether the employee relationship was severed over the last several months. And typically, if an employer says its employees have been furloughed, they've been placed on an unpaid leave of absence. If they've been laid off, they've been terminated as employees. But regardless of whether it was called a furlough or a layoff or something else, the real question is, was that employee separated from employment? And if they were, you're hiring them again. And so you need to start by looking at your policies and procedures for rehiring employees. If you already have something on your books, that's your starting point. In particular, thinking about documentation that needs to be collected. You may need to collect a new application form. If you typically do background checks or drug tests, the same laws that always apply to those things will apply again here. I-9 forms. That's actually an interesting one if you onboarded anyone new over the past few months, because you may be aware there was an exception to physical inspection of those verification documents while we've been shut down. But once you resume business operations, you have 3 business days to verify that documentation in person. So that's just something to be aware of if you did bring anyone on in this weird limbo period. New hire reporting is another one. In North Carolina, you have to report any new employees and anyone who has been furloughed for at least 60 days. So those are just some general things to think about. But again, it's really about hiring this person, right? You're bringing them back on as an employee. And then I do want to touch on benefits, because I think this is important whether you've laid the employee off or put them on an unpaid leave of absence. You know, the last thing that you want to do is inadvertently disqualify an employee for a benefit that they should be receiving. So talk with your plan administrators, talk with counsel as appropriate, figure out what you need to do to make sure that applicable 401k benefits or health insurance or any other benefits are still in place when this employee is onboarded for a second time. And so again, if they were not severed, then you're treating them like they are returning from a leave of absence. So again, the question is going to be, what is your policy for returning an employee from a leave of absence? What documentation needs to go in the file? Is it filling out a personnel action form, or is it something different? again, benefits coverage is going to be significant. Make sure that there hasn't been a COBRA event or something like that that needs to be papered appropriately. And again, you'll need to be cognizant of that new hire reporting requirement. All right, and so regardless of whether the employment was terminated or the employee's been on leave, there are a couple of things that employers need to be thinking about now. The first is, what's the foreseeability that you're going to go through another round of this in a couple of months? Some of you may have received PPP loan proceeds. If that's the case, you might be one of these companies that's in the position of saying, hey, we know we can reopen, but once those 8 weeks are up, we just don't know. Well, you need to talk to your legal counsel about whether a WARN notice might be required. And WARN is a program that requires notice to employees of an employer of a certain size if there's a mass layoff coming. And if you laid people off 8 weeks ago, you may have skated into the unforeseen business circumstance exception with these WARN notices. But you may need to either issue a WARN notice for the first time or amend a prior notice if it is reasonably foreseeable that those employees are going to be laid off again in the near future. Do any of the affected employees have employment contracts? So that might mean that you have a contract with a person for a year of employment, or it could mean something like a non-compete. Again, there are going to be questions specific to that contract about whether the time ran while the person was laid off. If you have a non-compete that says the person won't compete for 6 months after employment ends, have 2 of those months already passed? Or have you otherwise walked into a corner with some contract terms that you didn't foresee? So this is, again, a place where we are recommending review those agreements with your legal counsel to make sure that you understand the implication of the layoff or leave of absence as it relates to that contract. Loan forgiveness. Again, if you have a PPP loan, I'm sure you're very in tune to the loan forgiveness provisions and the fact that there is a headcount requirement associated with that. So we'll talk about this more in a minute, but you may have circumstances where an employee declines an offer to return to work for one reason or another. And it's important that if that happens, you need to document a good faith written offer of rehire, and you need to document in writing that the employee rejected that offer. Finally, insurance premium repayment. If you have the kind of setup where your employees are paying a portion of their health insurance costs through paycheck deductions, which many employers do, it's important to be cognizant of North Carolina's wage deduction laws when you're bringing those employees back on. So there are limits to how you can deduct, how much you can deduct. If this is a case where you're trying to play catch up or trying to get reimbursement for something you paid while they were out, it's important to just be in tune with what those requirements and limitations are. Benefits changes. Again, we talked about talking with your plan administrators, but this can also mean something like, are you going to have a revised PTO policy coming back? Either because you're concerned about making sure sick employees are out or because you feel like you need to police things a little bit differently. PTO is a great example in North Carolina because it's treated like compensation, and so changes can only be made prospectively. So if you have an employee who's got 5 days of PTO they accrued under an old system, they're entitled to not only keep those 5 days, but redeem them under the prior conditions. So it's really important to make sure that you're distinguishing between any new PTO terms and then prior terms. Changes to employee duties. I think this is highly likely as we're coming back with kind of an altered workforce, perhaps requiring us to be more nimble in certain ways. And if you have employees who are considered exempt from minimum wage and overtime based on their salary and their duties that they're performing in the workplace, really revisit that if you're having employees pick up more manual labor or administrative tasks than they did before, to make sure that they are still primarily performing the kind of duties they need to be performing to be exempt, or alternatively, transfer them to be non-exempt, just to make sure that you're on all fours with those laws. If you change someone's salary, over the last couple of months too. Think about whether you need to restore a salary level to ensure that they will be exempt going forward. And again, those are the kinds of things that need to happen prospectively. You can't retroactively dock someone's pay. And we'll dive into this more in depth momentarily, but you do need to have a plan for how you're going to respond to employees who don't want to come back to work for various reasons, and for employees who express concerns about coming back to work. And this is that tightrope situation I was talking about, where it's really important to have plans and policies on the front end so that your management knows how to respond methodically to these inquiries. But a lot of these situations are going to end up being fact specific. So you need to plan to be flexible, which is, I know, not the most reassuring or helpful, but we have some specific examples at the end that I'm hoping will give a little bit more clarity. So why might someone refuse to return to work? Well, we have brainstormed some examples right here that may or may not be what you hear, but I think a lot of these are going to be pretty common. The first, someone who is comfortable with the unemployment benefits they're currently receiving and they're making more money than if they returned. Someone who's concerned about COVID-19 in a general sense, certainly possible. I know I have contacts in my friend circle who are expressing that, and I'm sure I'm not the only one. Someone who says they can't return because they're high risk. We're reading all over the news right now about different ways that someone could be more susceptible to a more severe version of COVID-19. And then again, I can't return because I don't have childcare. These are all things that are going to be coming up over the next couple of months, and employers need to be prepared to respond to them methodically. All right, so I hesitate a little bit to lead with this one because employers need to be really cautious not to presume that the reason someone doesn't want to return is because they're comfortable with unemployment benefits. You don't want to inadvertently threaten or penalize someone who actually has a health reason that they just haven't felt comfortable expressing or something like that. But it's certainly a possibility that you'll have some employees who are just more comfortable drawing that unemployment benefit. So tone is going to go a long way with all of these situations. And this is the very first example. You know, you certainly don't want to threaten an employee or suggest that something bad is going to happen to the employee if they refuse to return. But it's equally important that the employee understand you as the employer have certain obligations for reporting to DES. And you're going to need to truthfully report and document with DES and with some of these other things we just talked about that you made an offer and the employee declined that offer. That could end up impacting their future benefits, but they could also end up having to repay benefits they receive after you've made the offer of employment. So as we're talking about threading this needle between informing them without seeming like you're coercing them to return to work, a great approach would be to just encourage that employee to review the FAQs on the the Department of Labor, Federal Department of Labor's website before the employee makes a decision, because the DOL has actually said that in certain circumstances, resigning from work to get unemployment benefits could constitute fraud. So the employee needs to be aware of the ramification of that decision if they choose not to return to work for that reason. All right, so this second one, I think we're going to hear a lot. I'm not comfortable. I'm reading a lot in the news and it's a scary time. We all know there's a lot of information out there, there's a lot of misinformation, and people are a little bit on edge. So this is, again, a place where tone is going to go a long way. And I think the first thing that you can do is engage with that employee to communicate all the things you're doing to make your workplace safe. All of those things Natalie walked through, precautions you're taking, policies you're implementing, every step you're taking that should make that employee feel more comfortable to return to the workplace. And you can ask that employee for specific things that they think need to be done. That doesn't mean you have to do what the employee suggests. But again, in a lot of cases, it will go a long way for that employee to feel like they're being heard and respected. And if they do identify specific concerns, try to address them. This is actually something we're all reading about a lot in the news right now, right? Employees who are getting fired for a Facebook post complaining about working situations, or a tweet or union activity or anything like that. And it's important to keep in mind that employees that have specific concerns about their working conditions are legally protected. So even though that impulse might be to discipline or terminate that employee for complaining about work on Facebook, if you think there's a reason to discipline or terminate that employee, check with your legal counsel before you move forward, because they might actually be practicing a legally protected right when they make that post. But in general, if they don't identify specific concerns, a generalized fear or discomfort is not sufficient to not return to the workplace. So this is where you would probably end up in the same place as an employee refusing to return for unemployment benefits, and you would walk them through kind of the ramifications of not returning and what your obligations are as an employer. All right, I can't return because I'm high risk. Again, something I think we're all going to be hearing a lot. So if you have dabbled at all in the ADA before, you know that the interactive process is key to interacting with someone who has a medical concern in the workplace, right? You need to show that you've engaged with them in a way that you are hearing their concerns and trying to figure out if you can accommodate them, again, assuming they're legally protected by the ADA. So best practice, rather than approaching individual employees, is to just open the door for that conversation. And you can do that now as you're preparing to reopen in 2 weeks or 3 weeks or whatever that may be. That's for a couple of reasons. Natalie gave the example of the well-intentioned employer leaving all older employees at home. Well, that actually just sets you up for a discrimination claim. It doesn't leave room for this interactive process. And if the employee can raise it, then the employee can determine what information the employee is comfortable sharing to start that conversation. Conversely, if you open the door and the employee doesn't raise that concern, then you can move on. And we've linked here to some really helpful EEOC guidance that, like all the other guidance, is changing on a regular basis, but they've got some really thorough input on working with high-risk individuals in the workplace right now. And if any employee you're talking to in this category has a significant concern, discuss that with your legal counsel to make sure you're taking appropriate precautions. Again, all of the usual laws apply here. We're just doing it in this elevated circumstance. So here's some great language that you could use as a starting point for that discussion, right? Please remember, if you have a high risk factor or any other concerns you'd like to discuss with us before returning, we're happy to engage in those conversations in a confidential manner. Our goal is to make all of our employees as safe as possible while returning to normal operations, and that will require good communication and mutual efforts. Again, here's this tone piece, right? We're trying. We really want to make sure everyone's safe. Please approach us if you have concerns. So there are kind of two high-risk areas that we're hearing the most about, right? One is these underlying health conditions, and the other is age. So if someone says they're high risk due to an underlying health condition and they're not comfortable returning, this is really the same as asking for a reasonable accommodation under the ADA. And again, there's that very helpful guidance. So if you're familiar with the ADA, you know the two pieces are going to be an individualized assessment and looking at whether you can provide some kind of reasonable accommodations before you jump to the conclusion that they need to be excluded from the workplace. So if the relationship has not been severed, if the employee has been on unpaid leave, that employee might actually be entitled to paid leave under the new leave laws. And if you've scaled back your operations in the past few months, I would highly encourage you to get up to speed on the Emergency Paid Sick Leave Act and the EFMLA, Emergency Family Medical Leave Act, because those are really going to intersect with your workforce, even if you have not been operating at full capacity. Those laws are going to stay in effect for several more months at least. And then in this situation where you have an employee who is high risk because of an underlying health condition, after those 2 weeks of paid leave, assuming they qualify for that leave, they might actually be eligible for unpaid leave as a reasonable accommodation under the ADA. So this is a case where, again, employers need to have a plan and a policy and then be prepared to work with the specific facts of a particular employee situation. So if the relationship has been severed, so they've been terminated, there's actually a good chance that employee will be able to continue receiving unemployment benefits because the reason they cannot work is COVID-19. I would probably refrain from counseling your employee through that because that's going to be a determination by the state, but you can take some comfort in knowing if the relationship's been severed, there's a little bit of a different analysis. All right, so then you have employees who say, I can't return because I'm high risk because of my age. So the ADEA does not have the same reasonable accommodation analysis, but given the EEOC's position on not discriminating just because someone is in a high risk category, our recommendation is that you do this same reasonable accommodation analysis. So reasonable accommodations might take a lot of different shapes here, right? They might mean additional PPE, they might mean assigning the employee to a different workstation, but the important thing is the employer is not the one who gets to unilaterally make that decision. That sets you up for a discrimination claim, right? You need to engage with that employee to figure out what they need to safely return to the workplace. And the barrier for excluding the employee from the workplace altogether is really high. All right, and this one too, I think we're going to be hearing a lot of. I can't return because I have no childcare. So again, if that relationship has been severed, this is another circumstance where it's likely that that employee will be able to continue receiving unemployment benefits. If the employee has been on unpaid leave, then our recommendation is to engage in kind of a reasonable accommodation exchange. Again, the goal here in a lot of ways is to make sure employees feel heard and that you find a way to represent your interests as an employer while accommodating this unique moment in history as much as we can. I think this is going to be the kind of thing where hindsight a year from now will lead to some quote unquote obvious answers for what employers should be doing. And right now we're just kind of learning as we go. So I think it's really important to give grace where we can and have policies and plans so that you know how to respond. You can engage with this employee to figure out if there's an altered schedule or reduced work or some other ways that that employee can work even in the absence of childcare. And again, the ESMLA might actually provide for 12 weeks of job protected leave due to the absence of childcare. After the first 2 weeks, that leave is going to be paid at 2/3 of the employee's regular rate of pay, and that leave can be taken intermittently. So perhaps the agreement you reach with that employee is that the employee works 4 days a week and takes leave on that 5th day. If that's going to be the arrangement that works out for everybody involved, then that's going to cover all of your bases. And the EPSLA will potentially provide 2 weeks of paid leave for the first 2 weeks under the EFMLA that are not paid. So it's a little bit wonky, but at the end of the day, there's paid leave that might be available in certain circumstances. And the employee can elect to use accrued vacation time for those first 2 weeks, but it needs to be something that the employee chooses to do. So this is an interesting question, right? What is the duty for employees to seek alternate childcare? I know here in Wake County, we're getting notifications all the time about summer programs that have been canceled or postponed or scaled back. And there's a real possibility that childcare is going to look very different this summer from how it typically looks. You know, there's not really great guidance, but this is a place, again, where I think a weekly check-in and letting employees, kind of opening that communication with employees can go a long way. You need to be careful that it doesn't come across like you're bullying them or retaliating against them for taking that leave. But I think it's a reasonable question to be asking if they're making any effort to find a babysitter or family member or something like that. If you reach a point where you believe there's a need to sever that employment relationship, consult your legal counsel, because this is such a murky area and because there's some protected leave in certain circumstances. You really want to make sure you have all of that buttoned up. And the EEOC has released some guidance on school being out for the summer. That by itself will not qualify an employee for paid leave. but that combined with the absence of childcare might. Can the employer go ahead and just terminate that employee so the employee can get unemployment? No, don't terminate an employee to get unemployment. The employee should not quit just to get unemployment. There are risks associated with that. You can implicate yourself in unemployment fraud, or it can come across like some kind of discrimination or retaliation. So the best course of action is to interact with that employee, figure out what accommodations can be made, and to document your efforts. So we have a ton of information available on our website. These are just some of the links that you might find useful, and we'll distribute this PowerPoint, I think, probably tomorrow. But if you have questions about how these precautions overlap with some of these laws that have been passed this spring, I highly recommend checking out some of our news alerts, a sample of which is posted here. And again here. So with that, I'm happy to open the floor for questions. I think we have about 9 minutes left, and you should have a way to submit questions through the little box on your screen. So I'll pause a moment to see if anyone has questions.
So while we're waiting for any questions to pop up in the Q&A screen, I will mention to people, I've had some inquiries about, gosh, it's a little overwhelming. How do we go through and do a plan like this? Reach out to us if you're in that situation. We're working on some different templates that might be useful to employers, different things like that. And again, a lot of these things are very fact specific. So a lot of times when we have these situations, people have a lot of questions they're thinking of, but they're not typing them into the Q&A because they know how fact-specific they are. And that's very true. Sometimes we have to just walk through the details of it, and there can be a lot of elements in play. But definitely reach out to us.
So I've had one question come in asking about some employees who do not appear to be in a high-risk category, refusing to return to work. And again, this is going to be a little bit of a fact-specific matter, but I will say as a general basis, a general fear of returning to work is probably not going to provide them with a legally protected reason not to respond. But I would encourage that employer to engage in an interactive conversation to identify any specific concerns and any open the door for them to identify any health issues. At that point, if the reason that they provide is just a general fear, then that's not a protected reason not to return to work.
I see a question that has popped up about testing. That's a really interesting topic right now because can employers engage in testing? The EEOC has issued some guidance and said that that may be appropriate for employers to engage in testing depending on the situation. So the answer is, yeah, it's possible. But the question that I would raise is, what is it that's being tested for? The current EEOC guidance says that testing for COVID-19. Most of the tests that would make it into the workplace are not actually testing to determine if a person has live COVID-19 virus, but is testing for antibodies. It's a lot easier, and there are quicker tests coming onto the market to determine if someone has antibodies. So what does that tell you if they do? And how do you use that information? So there's a lot there. And then how often would you need to test in order to have any usefulness for your workplace? A lot going on there. So we're definitely here to help. If you have a situation where you think you might be willing to test all of your employees, reach out to us. But it's a really complex issue right now without clear answers.
So I'll answer a quick logistical question we've gotten in a couple places, which is we are going to share this PowerPoint tomorrow. We're very happy that you're finding it useful, and we'll include with that email a link to our COVID-19 resources on our website, which is contains plenty of very informative news alerts. I'll move on to another question that asks about the reopening orders from Governor Cooper and how that relates to calling people back to the workplace. That is, again, going to be a little bit fact-specific depending on your workplace and depending on how those executive orders are written. I would be very, very, very surprised if the governor ever enters an order that says you are now required to call your employees back. So it's going to be an individual employer's assessment of when the time is right for a lot of different reasons, right? Are appropriate safety protocols in place? Have you reached a point that telework is no longer a viable option, or has it always really hampered your business operations? You know, we're all very anxious to get back to normal, and I think we all know by now normal is going to look a little bit different for a while now. So I think as we enter phase 2 in particular, we're going to start to see some business operations kind of pick back up. But I would be hesitant to give any definitive answers on the right time to bring your workforce back en masse. And whenever you do, you know, make sure you have a lot of those protocols in place that Natalie was mentioning about enforcing social distancing and hygiene and those kinds of things.
I would just add to that, you know, as we go through these phases, a lot of times you're going to see, and particularly we're in phase 1 right now, and it says it's still recommended that where possible, employees work from home, even if you're in the phase 1 reopening. So I expect we'll see that even in these phases, that there's still going to be some recommendations of wherever you can work from home, do it. And working from home may be a new normal in a lot of situations as well. I think it's been a very interesting test, and a lot of employers will be looking to say, did we have better productivity, worse productivity? What did it look like?
And I'll add to that, I'll admit to have some bias here because I'm someone who is anxiously awaiting childcare. But I think as part of your reopening procedures, it's just a great idea to keep in mind that there are a lot of different parts of people's lives that are opening right now, and so that will be a factor.
I see a question about under 500 employees versus over 500 employees for the leave laws that we mentioned. And yes, it is correct. There is an employer size matters on that. It's if you have fewer than 500 employees, then those new leave laws do apply. There are, of course, some exceptions, and there are some rules about when you view affiliated entities together and some joint employer issues. So if you have any questions about am I over? Am I truly over? Am I under? We can help you walk through those. I see another one about the employee doesn't have the underlying health condition that makes them high risk, but they are in a household with a family member who has an underlying health condition that makes that family member high risk, and therefore the employee is reluctant to come to work. So in that situation, I would say, assuming it's an under 500 employee business, that's going to be a situation that could fall under the leave laws. And specifically, the Emergency Paid Sick Leave Act has in it one of the reasons that leave can be taken is to care for a child who is under an order by a healthcare provider to stay home, to quarantine. And the reason that a healthcare provider might order that Doesn't have to be because they have COVID or COVID symptoms, but it may be that the person is high risk. So if a doctor has said this child is high risk and needs to stay home, and the employee needs to stay home to care for them, that would be a qualifying reason under the Emergency Paid Sick Leave Act. That act does limit the time to 2 weeks, so that would expire, and then you would be triggered back over into your normal policies, normal considerations and processes that you would go through in that regard. Again, though, we are encouraging employers, be flexible where you can, be accommodating where you can, go through that process and do what you can. That's the best way to reduce your risks, is to be able to show you've done all you could and still be operating as a business.
And I see we're at 3 o'clock, so I do want to be respectful of people's time, but our contact information is here on this slide. Please feel free to reach out to us if we didn't answer your question or if you have follow-up thoughts, and be on the lookout for that email with the PowerPoint and the link to the website. Thanks very much, all.